Welcome back, everyone, to the Raise Children After Divorce podcast. We really hope the first two discussions were helpful for you on this journey. Get ready for episode 3. Today, we're tackling something that can feel pretty complex, the legal side of things. This podcast is really taking off, which is fantastic to see. People are finding the practical, supportive advice from Daniel McMahon, the author of Raise Children After Divorce, incredibly helpful. And if you do want to go deeper after today, definitely check out his book, Raise Children After Divorce. It's available right now on Amazon Books. So today, we heard from some of you feeling, understandably, a bit overwhelmed by all the legal talk, wanting to feel more confident, speaking up for your child in these situations. Our goal today is to break down some of these core legal ideas, make them clearer, give you some actionable insights.
Yeah, and it's completely understandable why the whole legal process feels so, well, weighty. The idea of being in a courtroom,
Yeah.
decisions being made about your child's future, it can create a lot of anxiety. But it's interesting when you strip it back, the legal framework for custody really comes down to two main things. First, who gets to make the big decisions for your child? And second, where is the child actually going to live most of the time?
Okay, let's unpack that first one. Who decides? That's legal custody, yeah.
Exactly. Legal custody is all about the authority to make those really significant decisions concerning a child's upbringing. We're talking about things like education, which school, any special programs they might need, healthcare decisions, choosing doctors, agreeing to treatments, and sometimes religious upbringing if that's relevant for the family.
And it's not always a one-size-fits-all approach for that decision-making power, is it?
Not at all. You mainly see two structures: joint legal custody and sole legal custody. With joint legal custody, both parents share that decision-making power. Ideally, this means you need good communication. You need to agree on these big things. It really pushes for a collaborative co-parenting style.
And sole legal custody. That means one parent essentially has the final word.
That's right. So legal custody means one parent holds the exclusive right to make these major decisions. They don't legally need the other parent's okay. This might happen if, say, co-parenting has been really difficult, or maybe there are concerns about one parent's judgment on these key issues.
Okay, got it. So legal custody handles the big life choices. What about the day-to-day, where the child sleeps, eats, spends their time? That's physical custody.
You've got it. Physical custody determines where the child primarily resides. And just like legal custody, you usually see two main types here too: joint physical custody and sole physical custody.
Joint physical. Does that mean the child literally lives in two homes?
Pretty much, yes. It usually means the child spends significant time, often close to equal time, living with each parent. The schedule itself can look very different, maybe week on, week off, or splitting weeks. The main idea is a substantial amount of time in both households.
And sole physical custody is when one parent's home is the main base.
Correct. With sole physical custody, the child lives primarily with one parent, often called the custodial parent. The other parent, the non-custodial parent, then typically has visitation rights scheduled time with the child. That schedule can be set by the court or agreed upon by the parents.
Wow, okay. Understanding those differences, legal versus physical, joint versus sole, it feels really fundamental because it literally shapes the child's everyday life and who's guiding those big moments. For anyone wanting more detail on this, I really do recommend checking out Raise Children After Divorce by Daniel McMahon on Amazon Books. He explains these distinctions so clearly.
Absolutely. And knowing these types of custody naturally leads to the next big question. How do courts actually decide this stuff? The absolute number one rule, the guiding principle above everything else, is the child's best interests. Every single factor the court looks at comes back to that main concern.
Okay, best interests. That sounds right, but what does it actually mean in practice? What specific things does a judge look at?
Well, it weighs several key factors. The child's age is a big one, and their specific needs at that age. Think about it. A visitation schedule for a 2-year-old is going to look very different from one for a 15-year-old.
Right, makes sense.
Younger kids often need more frequent, maybe shorter contact to keep those bonds strong. Older kids might handle longer stretches, and their own opinions might carry more weight.
Yeah, that difference in developmental stage is huge. What else goes into the best interest calculation?
The court takes a hard look at each parent's ability to provide a stable, nurturing environment. Is the home safe? Is it supportive, healthy? They'll also consider the mental and physical health of each parent, because that impacts their ability to provide consistent care.
And you mentioned the child's voice. Does the child get a say?
Sometimes, yes. Depending on how old the child is and how mature they seem, The court might consider their preferences about where they want to live. But it's not the deciding factor on its own. The weight it's given really varies. A teenager's thoughtful opinion might count for more than a very young child's wish.
So it really feels like the whole point of weighing these different factors is to land on an arrangement that truly supports the child's happiness, their security, and just their overall healthy growth.
That's exactly the goal.
Hmm.
To create a situation where the child can really thrive, feel secure, and ideally maintain good relationships with both parents, assuming that's safe and positive for them. Now, we have to remember, life doesn't stand still, does it?
No, definitely not.
So the circumstances that led to the first custody agreement might change down the road.
Right, like what worked for a 5-year-old might not fit a 13-year-old dealing with high school pressures and different activities. So that brings us to modifying agreements. Are they set in stone?
Thankfully, no. Custody agreements aren't meant to be rigid forever. Life happens. A parent might need to move for a job, maybe far away, or a child's needs might shift. Perhaps a health issue comes up, or they need different school support.
So what are some common reasons people go back to court to change the custody setup?
A big one is relocation. One parent moving a significant distance, or maybe a major change in a parent's work schedule that really impacts their time with the child. Changes in the child's needs are also common triggers, like a new diagnosis needing special care or different educational needs popping up. Sometimes, unfortunately, a significant negative change in a parent's life or health might also prompt a modification request. Again, this is just scratching the surface. For a really thorough look at modifications, Daniel McMahon's book, Raise Children After Divorce, on Amazon, is invaluable.
And how easy is it to actually get an agreement changed? Is it a big legal battle every time?
It really depends. If both parents agree on the changes, it's usually much simpler.
Okay.
You can often just submit a revised agreement, sometimes called a stipulation or consent order, to the court for approval. But if you don't agree, then yes, one parent has to file a formal request, a motion, with the court. And in those contested cases, the court goes back to that core analysis. Has there been a significant change in circumstances since the last order? And, crucially, is this proposed change actually in the child's best interest?
So the best interest standard is still the bottom line, even for modifications.
Always. The courts generally understand that things change, and they're usually open to adjustments that genuinely help the child's well-being as they grow. It acknowledges that the best arrangement might evolve over time. Now, something really proactive parents can do to manage all this is create a detailed parenting plan together.
A parenting plan? That sounds like a good idea. What exactly is it?
Think of it as a custom roadmap for your co-parenting. It's a detailed written agreement that spells out how you'll handle things together. It's quite empowering, actually, because you're actively designing how your co-parenting relationship will function rather than just relying on a basic court order.
What kind of things absolutely need to be in a good parenting plan?
Oh, several key things. A really clear, specific visitation schedule is number one. Don't just say alternating weekends. Spell out pickup times, drop-off locations, cover regular weekdays, weekends, but also holidays, school breaks, summer vacations. Getting super specific here prevents so many future arguments.
That makes total sense. Holidays and summer can be real flashpoints if they aren't clearly defined. What else?
Definitely include how you'll handle special occasions, a child's birthday, Mother's Day, Father's Day, maybe significant family events like weddings or reunions. How can both parents be involved? How do you ensure the child keeps strong ties with both sides of the family? Another vital piece, decision-making. How will you communicate about choices regarding school, health, major activities? What's the process if you disagree? Lay it out.
So the more detail, the better, basically. Less ambiguity means fewer fights.
Precisely. Specificity is your friend here. A detailed, unambiguous plan leaves less room for interpretation, misunderstandings, and conflict. It sets clear expectations for everyone and gives you a shared document to refer back to.
And I remember seeing something about a parenting plan checklist and the resources. How does that help?
Yeah, a checklist like that can be super practical. It's basically a prompt reminding parents of all the areas they should probably cover. Things like the detailed schedules we mentioned, holidays, birthdays, decision-making protocols, communication rules, maybe even things like introducing new partners or handling travel. Parents can use it while drafting the plan, and it's also great for reviewing the plan periodically, maybe once a year, to see if anything needs updating as the kids grow. Again, for tips on building a really solid plan, Daniel McMahon's book, Raise Children After Divorce, on Amazon Books, is a fantastic guide.
That seems like a really smart way to stay organized and try to head off problems. Okay, shifting gears a bit, dealing with all this legal stuff, the terminology, the courts, it's daunting.
Yeah.
Which brings us to lawyers. How important is getting the right legal help?
Oh, it's absolutely critical. Seriously. You're stepping into what can be a complex, emotionally charged environment. You need someone who not only knows the law inside out, but also understands the nuances of family court, who can navigate the procedures and effectively fight for your interests and your child's best interests.
What should people be looking for specifically? What makes a family law attorney really effective in these kinds of sensitive cases?
Experience specifically in family law. You want someone who lives and breathes this stuff. Have they handled lots of custody cases similar to yours? Do they know the local judges, the local procedures? That deep familiarity is invaluable. Strong negotiation skills are also huge. You want someone who can be a fierce advocate when needed, but also knows how to be diplomatic, find common ground, and work towards settlements if possible. It's a real balance.
So, how should someone actually go about finding that right lawyer? It feels like a big decision. Is there a structured way to approach it?
Definitely. Do your homework first.
Yeah.
Prepare a list of questions before you start calling or meeting lawyers for consultations.
Good idea.
Ask specifically about their experience with cases like yours. How long have they practiced family law? What's their general approach to custody cases? Maybe even ask about their success rate, though that can be tricky to define. Don't be afraid to ask for references from past clients. If they can provide them ethically, see if you can find out about outcomes in their previous cases.
And the elephant in the room, fees. Legal help isn't cheap. What should people know about how lawyers charge?
Absolutely. Costs are a major factor. You need total clarity here. Some lawyers might offer a flat fee for a very specific task, like drafting an uncontested agreement. That gives you cost certainty for that piece. But more often, especially in contested cases, they bill hourly. Rates vary a lot based on experience, location, firm size. You need to fully understand the retainer agreement, that's the upfront payment. Ask about potential extra costs, filing fees, expert witnesses, photocopies. Get it all in writing. Transparency is key to avoid nasty surprises. Daniel McMahon actually covers navigating these financial aspects quite well in Raised Children After Divorce on Amazon Books, worth checking out for that alone.
Are there other options besides hiring a lawyer for full representation? Maybe if things are fairly amicable, or you just need advice on one specific thing?
Yes, definitely. Collaborative law is one interesting option. In that model, both parents and their lawyers all agree up front not to go to court. They work together, often with other professionals like therapists or financial neutrals, to find solutions. It's focused on cooperation.
Interesting.
It can be really good for preserving the co-parenting relationship. Another option is using a legal consultant. You hire a lawyer just for specific advice or tasks, maybe reviewing an agreement you drafted, or coaching you for mediation, but they don't represent you fully in court. It can be more cost-effective if you feel you can handle much of it yourself.
And that resource, the lawyer evaluation checklist, what would that typically cover to help someone make that choice?
A good checklist would systematize the evaluation. It would prompt you to rate or note things like relevant experience, years in family law, similar cases, negotiation style, examples approach, references, availability quality, communication, responsiveness, clarity, and of course fees, clear structure, retainer, hourly rate, estimated total cost. It helps you compare lawyers objectively based on the factors that matter most to you, rather than just going on gut feeling alone.
That sounds incredibly useful for making such a critical decision. Okay, so let's say despite best efforts, someone is heading to court. What's that actually like? What should they brace for?
Yeah, walking into court can definitely feel intimidating, maybe like stepping onto a stage you didn't audition for. But understanding the basic flow can really help reduce that anxiety. It usually starts with the initial paperwork, the filings. One person files a main petition, like for divorce, and includes requests for custody, support, etc. The other person gets served and has a deadline to file their response.
Deadlines sound important.
Crucial. Missing deadlines can seriously hurt your case.
Okay, so initial papers are filed. What's next?
Then you usually move into the discovery phase. It sounds like detective work, and it kind of is. It's the formal process of gathering evidence. Both sides exchange information, financial records, bank statements, pay stubs, maybe emails or text relevant to parenting issues, lists of assets. The idea is transparency, so everyone knows what the facts and figures are. This phase is also often where serious negotiation happens, because now everyone has a better picture of the strengths and weaknesses of each side's case.
And actually being in the courtroom, are there rules? Like, how should you act?
Absolutely. Courtroom etiquette matters. It shows respect for the process, the judge, everyone involved. Dress professionally. Business attire is usually best. Be on time, always. Address the judge as your honor. When you speak, be clear, calm, and truthful. Answer the question asked. Interact politely with the other lawyer, even if it's tense. No eye-rolling, no interrupting the judge. Maintaining decorum really does make a difference. Again, Daniel McMahon's book, Raise Children After Divorce, on Amazon Books, gives some great practical tips on court conduct.
What about paperwork? What documents should people have ready?
Good documentation is your best friend in court. You'll likely need financial affidavits, detailed summaries of your income, expenses, assets, debts, maybe inventories of assets, lists of property, bank accounts, investments. Communication records can be vital too. Emails, texts showing agreements or disagreements, parenting logs. The key is organization. Have everything sorted, labeled, easy to find. You don't want to be fumbling for papers under pressure.
This all sounds incredibly stressful. Any advice for managing the emotional side of going to court?
It is stressful. Acknowledge that. It's normal to feel anxious or upset. Try some stress management techniques beforehand. Deep breathing, visualization, whatever works for you. In court, focus on staying composed. Stick to the facts, not the emotions. Don't get drawn into arguments. Keep reminding yourself why you're there for your child's best interest. Focus on your goals. Maybe have a small grounding object in your pocket, something simple.
So preparation, focus, and emotional regulation seem key. Now, before things even get to a courtroom battle, there's mediation, right? Tell us about that.
Yes. Mediation is a fantastic alternative path for many people. Picture this. Instead of a formal courtroom, you're in a more relaxed setting, like an office conference room. You, your co-parent, and a neutral third party, the mediator. Their job isn't to judge, but to help you to talk productively and find your own solutions to the disputes. It's really different from litigation, where a judge imposes a decision. Mediation empowers you to craft the agreement yourselves.
So the mediator is like a facilitator, not a decision maker.
Exactly. They guide the conversation, help you identify the core issues, maybe suggest options, manage the communication flow, but they don't take sides or tell you what to do. It's usually voluntary. Both people have to agree to try it. And crucially, it's confidential. What's said in mediation generally can't be used later in court, which encourages open discussion.
What are the main advantages of trying mediation first?
Several big ones. It's almost always cheaper, often significantly cheaper, than going through a full court battle. Fewer lawyer hours, fewer court fees. It's generally much better for preserving the co-parenting relationship. Because you work together on solutions, it fosters cooperation rather than an adversarial fight. That's huge for the kids down the line.
Yeah, I can see that.
And it's usually less stressful and emotionally taxing than litigation. Again, Daniel McMahon's Raise Children After Divorce on Amazon Books really champions mediation and explains the benefits well.
How should someone get ready for a mediation session? Just show up.
No, preparation is key here too. Think beforehand. What are your main goals? What are your priorities? What are you willing to compromise on? Always, always keep the child's well-being front and center. How will different outcomes affect them? During the session, practice active listening. Really try to understand where your co-parent is coming from, even if you disagree. And go in with an open mind, ready to be a bit flexible. Mediation works best when both sides are willing to find some middle ground.
And if it works, if you reach an agreement in mediation,
Fantastic. Then the mediator, or sometimes the lawyers, will help draft a formal written agreement. This document spells out everything you agreed on: custody, visitation schedules, child support, maybe property division if that was discussed. It needs to be super clear, specific, and cover all the bases. Both parents need to review it carefully, ideally with their own lawyers, before signing. Once signed, it usually gets submitted to the court to become an official, enforceable order.
and that sample mediation agreement template concept, how does that fit in?
A template like that is basically a structural guide. It ensures you don't forget key sections. It would have spaces for legal custody terms, physical custody details, the full parenting time schedule, weekdays, weekends, holidays, vacations specified, child support calculations, how you'll handle shared expenses like medical or extracurriculars, maybe agreements on communication, and of course, signature lines. It helps organize the agreement and make sure it's comprehensive.
It really does sound like mediation offers a much more constructive, positive way forward for many families, focusing on harmony and what's best for the kids.
It really can be. It puts the power back in the parents' hands and aims for cooperation, which is always better for the children in the long run.
Well, we really hope this deep dive into the legal world has brought some clarity and maybe made it feel a little less intimidating. Remember, just understanding the process is a huge step towards advocating effectively for your child. And this has only scratched the surface of the insights Daniel McMahon shares in his fantastic book, Raise Children After Divorce. We can't recommend it enough. If you want a truly comprehensive guide, please pick up a copy on Amazon Books. This podcast is becoming such a valued resource. We hear that all the time, and the book just takes it to the next level. So take a moment to think about what we discussed, what resonated with you, what questions are still lingering. This is definitely a journey, not a destination, and we're here to support you. And here's maybe one final thought. Yes, the legal stuff can feel overwhelming, absolutely. But try to remember the core purpose behind it all, creating the most stable, loving, supportive environment you possibly can for your kids. Your understanding, your participation, your focus on them, that's what truly matters in achieving that. We'll be back soon with more insights and support from raised children after divorce.